Good evening and welcome to the 388th meeting of the City of Laurel Board of Appeals, meeting in regular session on Thursday, February 26, 2026 at 6:00 p.m. Let me start, since we haven't seen one another since December, by wishing everyone here a Happy New Year. I hope you all had a good holiday. Unfortunately, we don't get together often enough, Jay, Brooke, for us to kind of strengthen our camaraderie. But nonetheless, and those of you who, particularly with our law enforcement in the back, Happy New Year to you all as well. I'm going to start with agenda item number 1, roll call. Brooke, would you please call the roll?
Ms. Keating?
Here.
Mr. Johnston?
Here.
Ms. Clifford?
Here.
Mr. Wallace?
Here.
Chairman Smalls?
Here.
You have a quorum.
Thank you. Agenda item 2 is the approval of minutes from our December 18th, 2025 meeting. I hope you have had an opportunity to review those minutes. If there are no edits or additions to the minutes, I would call for a motion.
I motion that we approve the minutes.
Thank you, Ms. Keating. Is there a second?
I'll second the motion.
Thank you, Mr. Johnston. Any discussion? Seeing none, please call the roll.
Ms. Keating?
Yes.
Mr. Johnston?
Yes.
Ms. Clifford?
Yes.
Mr. Wallace?
Yes.
Chairman Smalls?
I vote yes.
Motion carries.
Next, we have a appeals application number 977 for 325 Gorman Avenue, filed by Mr. Andrew McCubbin. Sorry if I butchered that. We will have the reading of the file first, and then we'll give the applicant an opportunity to present.
Mr. Chairman, Jay Mishi, Director of the Department of Economic and Community Development. Good evening to you and to members of the board. I do have at least one topic to discuss before you commence the hearing and the consideration. You typically hear applications for variances and special exceptions from the requirements of the City of Laurel Uniform Land Development Code. And in those cases, my Department of Economic and Community Development authors the staff reports which analyze applications and compare them to code requirements. This instance is different. The applicant this evening is appealing an administrative decision of the Department of the Fire Marshal and Permit Services. Board Secretary Ms. Herring and I are involved here only because the Board of Appeals is staffed and supported by the Department of Economic and Community Development. We did not author any of the documents submitted to you on behalf of the city, and we have no position on this matter, in contrast to when you consider a variance or a special exception. My primary concerns this evening are to ensure the integrity of the Board of Appeals and its process, and to ensure a complete and credible record of the board's proceedings in case this matter is appealed to the Circuit Court of Prince George's County. The Department of Economic and Community Development receives an applicant's filings and provides them to you with your packet. The rules of the Board of Appeals for the City of Laurel, adopted on September 24, 2015, list the requirements for all petitions for special exception, variances, and administrative appeals. It requires the applicant to file an original pre-hearing statement no later than 15 days prior to the date set for the hearing. Today is February 26th, therefore the applicant's pre-hearing statement was due to my department by February 11th. Your rules require the applicant to submit, quote, copies of all reports, studies, and other documents and plans intended to be introduced at the hearing, end quote, by that deadline. The rules also say that failure by a party to comply with that requirement, quote, may be cause for refusal to accept the pre-hearing statement and or cause for postponement, continuation of the hearing, and or decisions to leave the record open for specified time to permit rebuttal evidence. The applicant uploaded 50 items to our digital application portal on February 20th, 9 days after the rules require copies of all documents to be filed. 47 of them are named Exhibit followed by numbers, letters, or a date. 1 is named Second Amendment Board of Appeals brief, and the applicant named 2 of them motions. Department of Economic and Community Development staff provided board members with the 2 motions filed in accordance with the rules, which do not specify a deadline for parties to file motions with the board. Staff have not provided the additional 48 files because the applicant submitted them after the deadline, which prevented my department from organizing the files, presenting them to you and to the Department of Fire Marshal and Permit Services in a way that is consistent with board rules and practices. As your principal support staff, I respectfully request you provide direction on how to deal with the 48 files that were submitted after the deadline. As I mentioned above, the rules provide you with 4 options regarding these files. You may refuse to accept them, rely only on the documents that the applicant submitted on or before February 11th, which are the ones that were included in your packet, and hold the hearing this evening, which will conclude with your ruling. That would prevent the applicant from introducing those 48 pieces of evidence or exhibits this evening. You may postpone your hearing of this application in order for you to review the files and for the other party to examine them and prepare rebuttals to them. You may accept them and continue this evening's hearing, where you will see them for the first time and rule on the application at the conclusion of this hearing, or you may accept them and continue this evening's hearing, but leave the record open for a period of time you decide on in order to allow the Department of Fire Marshal and Permit Services and individual members of the public to submit rebuttal evidence if they so choose. If you decide to hold the hearing this evening, I will then move on to address a question that one board member submitted to the department seeking additional information or guidance to specific parts of the city code. It is important that you each receive the same information from me, just like you each receive the same board packet. Thirdly, and again, if you decide to hold the hearing this evening, a board member submitted a question to the department regarding the applicant's pre-hearing motions. As those are questions of law and not of board procedures or administration, I must defer to the solicitor regarding those. So I now respectfully ask you to render a decision on how to deal with the 48 files the applicant submitted.
Thank you, Mr. Miche. Okay, so.
Mr. Chair, I need to object to that.
Okay, let me address and then I'll get to you for whatever you want to add, or contribute, I should say. Okay? So the order of business before us first is how do we proceed? Based on what we've just been presented, I will put it to the majority of this body on how we proceed this evening. Would you go over one more time exactly what those are, so I'm sure that
Absolutely.
we all got it?
And again, to be clear for the record, these are the options that are presented in the rules of the Board of Appeals. You can refuse to accept these things that were submitted after the deadline, and that means you would rely only on the documents that the applicant submitted within the provided time limit. Hold the hearing this evening, which will conclude with your ruling, but in that case, he would not be able to introduce those 48 pieces that he uploaded. Or you can postpone your hearing of the application, and you and the other party, which is Fire Marshal and Permit Services, would have an opportunity to examine these things, and Fire Marshal and Permit Services would be able to prepare rebuttals to them. You can accept what he uploaded, that is in your discretion, to waive the deadline and continue the evening's hearing, and you can rule on the application at the conclusion of tonight, or you can accept them, go through with the hearing, but not rule tonight, and leave the record open so that any interested party can provide rebuttals or comments on the evidence.
Okay, thank you. Now, Mr. Coven, I will give you the opportunity to make your statement before this body determines what direction we're going to go in this evening.
And please do make sure to press the button to turn on the microphone so that you're captured for the record.
So I'm simply objecting to.
Sorry, could you please state your name for the record?
Sorry, my name is Andrew McCubbin. I'm the appellant. I am objecting to Mr. Miche's assertion that my records cannot be admitted when the staff report was also late. It was submitted 6 days prior to the hearing, not 7, as required in the Land Use Code of Maryland.
Thank you. Okay, board members, comments? David, you seem like you're chomping at the bit.
I am. And there's a lot of data to go through, and I feel like a masochist saying, yeah, give us more, but we'd have more time, we'd need more time to evaluate this. If this is headed to circuit court, maybe if it's within the rules and the bounds of what this board does, we can declare our intention to disallow some of this evidence. But to disallow it because I missed a filing deadline, I'm on the fence on all of this, so, and I have some questions for the attorney, that's a zoning attorney. But,
Could we?
what's the mood of the other panel? That's just,
Could we have a description of the exhibits?
yeah, the 48, you have titles of the 48.
Well, I mean, the appellant knows the exhibits the
Right,
best,
right,
they're
right,
your
right.
exhibits, right?
What are we missing by not letting you
Yeah.
include these 48 items, okay?
The majority of the records are email correspondence between myself and the Department of Fire Marshal and Permit Services and other staff of the city. And so that's the majority of them. There are videos and images that are referenced in my brief that I submitted to the board submitted to Department of ECD on February 2nd, and that sounds like was not transmitted to the board until last week. Those exhibits were named there, and I specified that I would be submitting amendments once I had a statement of the record that's required to be submitted under the land use code for the city. The records that were submitted and amendments to my original brief were due to the fact that the city submitted their staff report, which wasn't a record of events, wasn't a statement of the record, and I had to respond to that. Thus, the motion to suppress that record, and I believe that's something that the board needs to act on, because if the city doesn't have a case that they've submitted, they have no defense. They have, my defense has to stand alone. They have no prosecutorial evidence to submit whatsoever.
Thank you. Mr. Wallace?
Just a
Okay,
question.
sorry.
His evidence, is that part of what
let's
we
keep going.
can
You're-
rule on? Because I know there's some things that are out of our jurisdiction. So is that, what he's submitted, is that part of what we can, is that part of our jurisdiction, or is it not?
If I could jump
Please,
in,
yeah.
Nate Foreman, counsel. So the issue is that, and as Mr. McCubbin has said, that he believes that there was a delay in the fire marshal and permitting services issuing the staff report, and therefore he felt that he was prejudiced in submitting his rebuttal. The issue and concern that I think that I would have for the Board of Appeals is that the information that has been submitted is voluminous, and Economic and Community Development hasn't had a chance to get through and review it for its merits, whether, for justification in this case, or just take it for its face value. And that if there is a concern with what this evidence is, you could either go forward with what has already been in the record, or the hearing could be continued for a chance to have that evidence be submitted and reviewed and have a chance for rebuttal. I would say if Mr. McCubbin wants to have a hearing tonight, I think, I can't tell him what he should or shouldn't do, but I think I would recommend this board then continue it to allow that information to be reviewed and fully vetted before it's being introduced. Unless, of course, Mr. McCubbin has each and every document and several copies of each to go through tonight, which I don't think would be how this board would want to handle that.
Thank you. Mr. Wallace?
Could I have the staff, the council opinion on the relationship between the two deadlines? Right, so there's a land use deadline of 6 days, and then our rules, I think it's section 10. Is that what we're referring to for the pre-hearing requirement deadline of the 15 days? Do you have an opinion about the relationship between those?
If you just give me a moment's indulgence
Yeah,
to make
sure.
sure.
And Chairman, just while we're waiting, could I ask an additional question?
Please.
So for Mr. McCubbin, right, obviously, we are where we are. You have things you're trying to get done on your property, so there's a practical element to that we want to recognize. We haven't seen these exhibits, right? We got the briefs, we got the motions, but not these exhibits. So as you're processing this, do you have an opinion on how you would like to see us proceed?
If I may, my opinion on the exhibits, specifically a set of emails and some of the other exhibits, I would have to go through and give you an accounting of which ones I would exclude based on excluding the staff report. If the board wishes, I will exclude those as long as the staff report's excluded, to basically just enter in the appeal that Mr. Selby made on December 23rd, for which this appeal arises. His decision is what I am appealing ultimately. The staff report's not relevant. Some of my exhibits, majority of my exhibits aren't relevant if the staff report is not admitted.
Okay. If we said, we'll accept all of it, but you're going to have to bring up the ones that you want to bring up to our attention tonight because we haven't seen them in advance, that's another option. Right, do you have an opinion about that? Would you rather proceed tonight if we want?
I will still ask the board to act on the motion to suppress. and the
Sure,
motion to-
you still have your motions. This is just the preliminary question of your evidence getting into the record.
Sure.
And then how we would actually handle it tonight. Okay, it would be up to you to bring the exhibits to our attention
Sure.
as part of your presentation.
Yes, I can do that. I have them available.
So if I, looking at
just a
the
second.
rules and procedures for the Board of Appeals, there is a requirement that the applicant submit the information no later than 15 days prior to the date of the hearing, and then any party in opposition has then 7 days. There is no real, as I would look at this, any requirement, if I'm wrong, for the staff report to be provided those 15 days.
Hold on just a second, just a second, sir, just a second. I want to make sure that everyone here, for what's been presented so far, that we're discussing options. Ms. Clifford has also an opportunity to weigh in on this. We've heard from everyone else before we get too deep down in this rabbit hole.
I'm not sure that we have had enough time at this point to review all of these points that we need to understand and take in. So that's where I stand on this.
Thank you. And I'll weigh in as well. I'll just simply say that I would prefer to see all of the evidence that was submitted by you, sir, so that we can properly and completely weigh your position against what the city's position is. I think in fairness to you, as well as in fairness to this process, that would be, in my opinion, the route for us to take. Saying quite simply that my position would be that we postpone until a later date, until we have the opportunity to review all of your exhibits, all of the information that you have provided, for us to render a fair, with everything included, decision on this matter. Sir.
Mr. Chairman, thank you. 2 points of sort of information for you. The first is that there will be a March Board of Appeals meeting. We already have a special exception application that has to go to you. So I can say with certainty that you will be again meeting in March. And I also, my reading is that the board can meet at the call of the chair. And so that you are free to set another date. It does not need to wait until the 4th Thursday of March. And so I want you to be sort of cognizant of that. And without overpromising, also, if you elect to postpone the hearing, I can say with confidence that by Friday, March 6th, staff will have time to sort of collate the exhibits that were submitted to the either February 2nd pre-hearing statement that the applicant submitted, or if you would like, to the one that he submitted on February 20th and called the second amended brief. If you think that will be of assistance to you, sort of for me to say, you know, Exhibit B 2025-12-13 is referenced on page so-and-so. So I want to provide you those options.
Thank you.
Would you entertain a quick comment?
I'll entertain a quick comment. You need to give your name and address for the record, please.
Name is David Dixon. I'm a resident of Box Elder, South Dakota. If you want the full address, I can give it to you, but the thing I'm going to comment with respect to timelines and all, Mr. McCubbin filed his appeal on January 2nd, which was one day before the deadline after Mr. Selby's decision. Code only gives him 7 days. That brief you got was 7 days, taking into account Christmas and New Year's. He had to work fast. He submitted that on January 2nd. The board's had that now for just shy of 2 months. And the city didn't respond with its staff report, didn't present that to Mr. McCubbin until 6 days before this hearing. If all of his new issues or new exhibits, excuse me, are raised as a result of new issues raised in the staff report, it kind of seems like we're playing on an unlevel playing field here, where the city has all the time in the world to respond, and everything he has to do is on a very short timeline. Just would like you to take that into consideration as you make your decision tonight. Thank you.
Well, I'll just add or submit that based on our council's interpretation of timeline, I would stick strictly to the strict timeline that's in our code when things have to be submitted. Holidays, et cetera, and to me, are no excuse for not getting things submitted according to what the requirements are. So once again, we have these options before us. We've heard from the applicant and Mr. Dixon. So it's before we can proceed any further, we should decide exactly what we're going to do. And once again, preferably, I would like to have everything. It took a couple of days to digest, to review, to look at the code, et cetera, for the packet we received. I want to make sure that I don't miss anything as I'm preparing to render my vote on this application. I can't speak for my colleagues, but we will come to some consensus here in a few minutes as to exactly how we proceed with the application. But I'd like to have everything to review. And again, as I stated, I think it's fair to the applicant and it's fair to staff and this body. If we choose to read it, that's one thing, but if we don't, that's another.
I agree. I mean, this is a lot of information. I would like to have everything, be able to digest and get my questions in order.
I have a question about asking questions to our attorney. Can I email him, or do I only get to do that during the hearing? Because as I'm reading this material, I'm coming up with a dozen questions, okay?
It depends.
I could ask one right now that's kind of like going down the rabbit hole, but this might be typical of the questions I would ask. All right, let me do the rabbit hole question. All right, so he's threading the needle, like, is it Dr. McCubbin? Is that, okay, yeah, PhD physicist. So I was a physics major before I switched my major. So you and I are probably the ones who spend the most time around PhD physicists. I could tell from the complexity of what you're doing that you're trying to thread the needle and trying to argue that you don't need a building permit. And part of it rests on the fact the structure is 200 square feet, but he's making it taller. So the question for the attorney is, does making it taller violate or let us into requiring a building permit? If you understand the question.
I understand
Okay.
the question, but I actually would
can't
prefer
reach that.
if that being directed to the chief building officer, who is the one that does interpret the
Okay.
codes. So it sounds like that's more of a substantive question that would be more appropriate for the hearing itself.
All right.
Where you would have a chance to ask the chief building officer, Dr. McCubbin would have a chance to hear and cross-examine and listen to.
Right, and that's just one of the questions I have in my head, so it's like a question about asking questions, so it's like, get it to, well, I don't know if you want me to burden you with an email and then, no, I'm the wrong person to answer this.
Well,
Or do I have to share with the rest of the board when I send you emails?
So for those substantive questions, I feel like I would like you to send them to me.
Okay,
As in, that way we can compile them, because they may be better to be addressed in open session than for me to provide my legal interpretation outside of the open session.
right, you need to think about it, it's like,
Yeah,
for those of us taking the bar exam, it's like legal drag racing, okay? You wouldn't do that in a court, okay? And that's why if we're gonna postpone this hearing, we can, I've gone through about 2/3 to 90% of it, and it's just, I still have questions.
Just to,
And I would like to commend the appellant, he's found some mistakes in the hyperlinks or something, or sometimes the code's referenced in the wrong section. We had an election issue here as a board, I found 3 hyperlink issues. There was a county councilman here who found 7, so if we find mistakes in that, we should bring that up as an action item, and we did that a couple of years ago, to clean up the online presence of these codes, because other people besides us rely on them.
Thank you, Mr. Johnston. Mr. Wallace?
just as we're referencing our opinions, Mr. McCubbin has been, he's been working on this project for a while. We're not passing any judgment on the merits of the project, so just personally, I'll say it looks like a good project, right? I'm sure he wants to get it done. We have a lot of evidence in front of us. I think if the applicant is willing and understands what he's walking into, I would be in favor of accepting it into the record and having our hearing tonight. Sometimes justice delayed is justice denied. It's a month. It's not 6 weeks. I don't want to press that too far, but we're here, he's here. I'd be more inclined to go forward.
Thank you. Any other comments, questions for staff, council? Okay, with that said, I would entertain a motion on how we proceed tonight.
All right, I'll make a motion that we accept the exhibits that were filed after the board's 15-day deadline and proceed with the hearing tonight.
There's a motion, is there a second? Hearing no second. That motion fails. Is there another motion?
Make a motion to delay this till the next meeting we set up, whether it's the fourth Thursday of March or so. So we have time to review the information in a little more detail.
Okay, so.
And to give the city, the attorney, some time to answer if I have a dozen more questions to ask him. Okay. Or I'm going to try to figure out the answers on my own, but,
No, please direct them towards me.
okay.
Thank you.
I have a law degree, but you have more zoning experience than I do. Okay. All right, thank you.
Understood, thank you.
There's a motion, is there a second?
I'll second.
There's a motion and a second, any discussion?
Can I ask a clarification point? As part of this motion, are we accepting into the record now the exhibits? Right? That's what I'm understanding. I just want to make sure that
Staff
that's
will be
clear.
providing us with.
So they're going to
those
provide them all through
exhibits.
it? Okay.
Exactly.
Okay,
Exactly.
that's part of the motion.
Yes.
Great.
Yes, yes. So, any further discussion? If none, Brooke, would you please call the roll?
Mr. Johnston,
What's the motion again? Defer,
You made the motion.
oh,
It's to postpone.
right, okay, all right. Because I didn't give a set date, but we'll figure it out.
No, that'll be up to staff
Okay.
in
all right.
following the rules.
Yes to my own motion. Okay.
Ms. Keating,
Yes.
Ms. Clifford,
Yes,
Mr. Wallace,
Yes.
Chairman Smalls,
I vote yes.
motion carries.
Thank you. So, Doctor, here's where we are. If I understood you correctly, our staff already has your full package of information. It was just that we got a portion of it. Is that,
With one exception is I still have not been able to transfer the videos because they are quite large, and so I'm going to coordinate with ECD to do that.
well, is it possible that perhaps you put them on a thumb drive?
They are currently-
Enough for each one of us or staff, or however they work that out?
If they would like to provide each one, that's fine, I can transfer them to staff to do so.
Mr. Chair, Dr. McCubbin, if she doesn't mind, would put our Deputy Director of Information Technology on the spot and ask if she knows a way that she would prefer to get those. I don't want to leave this hearing without knowing that we're going to get you all of the information.
Neither do I.
Okay, so, by Thursday, I'm sorry, by the 6th, March 6th, if you can provide us with a thumb drive, or if you have it this evening, then we can make sure that it's in a format that the board can access.
Right, I just don't favor OneDrive. I hate OneDrive. I told Brooke I would say that in the hearing. I have friends that hate OneDrive, and network and engineering friends. Okay.
Okay, so, sir, you will be notified, obviously, in writing of the date of our next hearing from this period until then. You'll provide staff with the information that we don't have so that we can digest in total all of the information that let's face it, you didn't put that information together for it not to be presented. If this is any indication of the level of effort that went into what you submitted, then I think it deserves to be seen. So we'll go from that point. I think staff is clear as to the direction we're going in, and hopefully you are as well. If you have any other questions that you want to present to the board tonight, please do so. If not, you'll communicate with our staff on how things are progressing. Thank you very much for your application. Thanks for your time tonight. So this matter is
Thank you, Mr. Chair.
closed. Thank you. Is there any other business to come before the board?
Not from staff.
Well, we seem to have a new face or two that's seated there.
Surely, Mr. Chairman. As you know, longtime sort of city solicitor, Larry Taub then stepped sort of sideways into the role of being the land use and Planning Commission and Board of Appeals attorney. One of his colleagues stepped up to be the city solicitor. Larry has now, to the best of my knowledge, retired. And Nate Foreman of the same firm has perhaps graciously, or maybe he's just wearing a good smile about it, agreed to work in that land use infractions Planning Commission and Board of Appeals role. And I would, if you would like, I would offer him a chance to introduce himself.
I would very much like it. Hopefully my colleagues here would as well. We can either do it tonight, just in general, or I'll go back to my old city council days when particularly a new solicitor came on that we could hear from him individually, that is, via either a phone call or an email. We may have questions or for you that don't come to mind now, but may come out in a phone conversation or a text or an email. So please, we'll allow you to speak now, and perhaps we can work something out later where you talk to us individually.
Thank you very much, Mr. Chair. It's an honor to serve as legal counsel to the Board of Appeals. I know I am coming into big shoes that Larry is leaving. I will disagree with what Mr. Michi has said. I don't know if Larry will ever fully retire, but now he's stepping back and just wanting to do the type of work where he doesn't actually have to be anywhere at anyone else's time. He gets to show up and do what he wants to do. So I'm looking forward to serving as the Board of Appeals attorney. I'm looking forward to serving in my faculty as a city solicitor for the City of Laurel. I'm more than happy to provide email, phone, any way of getting a hold of me to answer any questions the board may have. I have extensive experience working in Prince George's County doing land use and zoning work. Our firm also works for the City of College Park, so we have a good mixture of understanding land use issues, municipal issues, and even recently, I am now the zoning counsel for Howard County, working on piecemeal change of mistake arguments. So I kind of have dabbling my hands in a lot of different pots here, understanding a lot of these, how government operations and jurisdictions look at and handle land use issues. So I'm more than happy to help out any way I can.
One, I'll call it point of order, so to speak. I would like, and hopefully my colleagues would agree, that any questions that come to you from any of us be shared with all of us. We oftentimes think with like mind, so there's no point in you getting 5 phone calls or 5 text messages from each one of us asking the same question. So at least if we have the opportunity to share that information, I think that would go a long way for all of us. So.
Thank you, Mr. Chair. I think that's a great idea, and I'll work with Ms. Herring to make sure the board has my contact information, and I can get everyone else's contact information. We can kind of start communicating.
Perfect, perfect.
Thank you.
Thank you so much and welcome aboard.
And is your office on West Street in Annapolis? Is that your primary location?
That is the accessory office. That is for the lobbying side. Our main office is actually located in Greenbelt.
Oh, okay. I used to live in Greenbelt. I know the way. Okay, thank you.
Well, if there's nothing else to come before the Board of Appeals tonight, I'm going to tie my shoe and bang the gavel and say we're done, and see you in March. Thank you, sir.